Welcome back, folks. This is the Law and Crime Network. We have breaking news now. We've been in verdict watch in the case in Florida against Ashley MacArthur. The judge is on the bench now. Why? Because we are hearing there is a verdict in the case after about 2.5 hours. Again, this is the case against Ashley MacArthur, who has been accused of first-degree murder in the death of Miss Taylor Wright, the 33-year-old. And this defendant, former CSI officer, has really undergone quite the scrutiny in terms of this circumstantial case. There have been all kinds of bits and pieces suggesting by the prosecution that she is, in fact, the one who done it. But there is no gun. There is a body on the farm owned by the family of the defendant, and there are lots of other circumstances putting this death at the hands of Ashley MacArthur. While we're waiting for the jury to reconvene and that verdict to be read, I am happy to be joined by a number of folks here in studio. I have Katie Catherine Smith. How are you, Katie?
Good. Thanks for having me.
You bet. Trial attorney here. Also with us is Eklund Mercy, criminal defense attorney. How are you? How you doing there, Eklund?
Good. Thank you for having me.
You bet. And sticking around, I don't know how he's done this after being with Aaron Keller for so long, but he's got enough energy. He's sticking around. John Phillips, how are you, bud?
I'm hanging on. I have a verdict watch, and now that we have a verdict, I'm just kind of hanging on to my Law and Crime.
And this is not too far from you. You're in Jacksonville. This is going on in Pensacola, so kind of in your hood there. So maybe you'll have some local insight that might help us. Let me ask you first, John. Surprised at how relatively quickly this jury has come back with a verdict?
I'm not. Having sat through all of closing arguments and knowing how severe it is, it's right in that window. And in fact, right before they announced the verdict, I said by 4 o'clock. They beat me by an hour.
Okay, you lost the pool. I think Rachel Stockman here, she had 3 o'clock. I think she wins cookies. Let me ask you this, Eklund, because timing has been critical in this case, not just in the circumstances and the timeline, but the fact the judge has moved this thing along. We got to get going. We got to get out. We're going to court. Are they ready? Okay, hold your thoughts. Going to court. No surprise, the jury being polled there to make sure that everybody is in agreement on this verdict, which is guilty of first-degree premeditated murder with the aggravation of a firearm, which is kind of irrelevant in terms of the sentencing. This is an automatic life without the possibility of parole in Florida. They didn't go for the death penalty here, so the default is LWOP, and that's what the jury gave her. In our experience, she'll be cuffed and hauled out right there. Let me get back to Eklund Mercy. I'm still concerned about the timing with which this all unfolded and the whip that the judge seemed to put to all the players in this. Does that concern you?
Unfortunately, actually, for this particular case, it really doesn't. The amount of it was a circumstantial evidence case at best, but it was just too much. It sounded like the trial was basically the longest plea I've ever seen in my whole life. It was just, the defense wasn't there. The prosecution hammered in on every key point. So it was a no-brainer. With cases like this, it usually does take 3 days.
So, Katie, let me ask you this question. As we've now taken in the verdict, it's a fresh verdict of guilty. We know there's going to be appeals coming. How do you think the pressure the judge put on everybody might play into any appeal?
I mean, I think the real question is, was there anything that the defense should have done that they weren't able to do due to these time pressures? And as Eklund had said, the quantum of the circumstantial evidence, even if they were able to, potentially put up another witness or another fight, it's just, I don't see that it's there. From day one, I thought we were going to have a guilty verdict.
John, that's why it concerns me a little bit, I think. In this case, maybe there was an overwhelming amount of circumstantial evidence, and maybe the verdict, therefore, no surprise. So maybe, therefore, this pressure to move things along is lost in that whole analysis, but does it make it right?
It doesn't, and the defense really didn't protest of the whipping, and they all understood. You've got a hurricane coming, you've got Labor Day weekend, you've got reasons. Certainly, there may be emotion. There's going to be emotion for a new trial. There always is. The brief depiction of her holding the gun. There's things that they'll protest over, but again, the digital footprint that the now convicted murderer made is what ultimately convicted her. You can call it circumstantial, but it was evidence.
Eklund, you've probably watched this defendant interact or show no emotion many times throughout the course of this trial. What do you think of her reaction here upon hearing the verdict, and is it sinking in?
Well, here's the thing. I think she checked out a couple of days ago. I think she, after like the third viewing of the video, I think she actually checked out. I think at this point, I mean, it is what it is. She knew the verdict early on. You can see that she wasn't really interacting with her attorneys like she was prior to. I think she checked out a couple of days ago.
You know, Katie, we've talked about this defendant through the course of this trial and how she seemed to be maybe just too smart for her own good, not in only how she handled the cops during those interview sessions, but in just her attitude while at the defense table. Thoughts on that?
I agree. You always have to know that every single thing that you do while in court is going to be under the microscope. I mean, you're literally sitting right in front of the jury. And this, even if you check out, those things are registered by the jury. It's so important to, meaningfully interact during the trial, to show emotion when things are sad. Her stony sort of front, I don't think helped her, but at the end of the day, again, the evidence was so overwhelming, whether she cried or not wouldn't have made much of a difference.
The defense, John, in this case really pounded away on the physical inability, in theory, of the defendant to, haul that concrete around and maybe move a body and dig a grave and all of that. Apparently the jury didn't go for that. And I'll tell you now, more than you ever cared to know about fast-setting concrete. It usually comes in 40 or 80-pound bags. Big difference. And I couldn't tell from the photo that was shown what was the weight of the bags that she purchased. The other thing that's interesting is when that fast-setting concrete sets, and it does so in about 20-30 minutes, it gives off heat. And I'd be curious to see how that affected the body and what was done over a period of time with the body. What do you think about that, John? Not to mention the monsoon and the hot weather in Florida you have there.
Right. Everything about that, I didn't buy. Their main witness was a chiropractor, for crying out loud, not an orthopedic surgeon or a neurosurgeon. And they just gave her conditions that you can still have physical activity, you'll just have more pain. And the alibi was she put a 40-pound saddle on a horse and rode around acreage.
Okay, hold on, John. Hold on. We're going to go back into court. Stand by. Okay, this is my confused look. John, let me ask you this. You're in Florida. It's been our understanding that in a case in which they don't seek the death penalty, but it is premeditated first-degree murder, that LWOP is kind of the way it goes. Now she's being told that she's getting a minimum of 25 years. Explain.
I think the judge misspoke. As I understand it, the 25 years is essentially the add-on to the life. You can run it concurrent, but life is life. As I understand, I think the judge misspoke. I can, look as soon as we go into a break, but this should be life.
Yeah, without parole, correct?
Without parole.
Okay, good. Yeah, maybe she was in too big a hurry and she got it wrong. Okay, so Katie, let me ask you, again, we're sitting there watching the defendant react to all this. She opted not to speak, but you picked up a little body language there when, Joan Parker, the victim's aunt, is speaking. Heartfelt comments about the loss of her niece. What did you see?
I saw a little shifty eye roll. I don't know if you guys caught it, but she kind of looked off to the side, and I could see this almost like this exasperation seep through, and it was just, it's not good.
No, that's not a good maneuver. Eklund, what's your take on the defendant's reaction and the immediate sentencing? There she is getting the cuffs put on, by the way.
Yeah, well, I mean, what can you do? She hasn't shown any type of emotion the whole trial. So for her to show some emotion right now, it wouldn't even make any sense. I think that she should be working on an appeal. I think that she has basis for appeal, which is because it was rushed. And because it was rushed, although for a good reason, it was rushed nonetheless. And maybe ineffective assistance of counsel, who knows?
Okay, well, there she goes. She's on the plus side. That 7 years she got for racketeering is probably less an issue for her now. We're going to take a quick break. When we come back, we're going to dig into what this jury had to chew on to get to the verdict they did. Again, Ashley McArthur, guilty, first-degree premeditated murder with a firearm, and she is off to prison essentially for the rest of her life. We'll be right back. This is Law and Crime.